I do have skills that make me a nightmare for people like you.
Okay guys, so in part 9 we left off showing you the transcript and the email that I acquired from Rita. This is the correspondence from 26th of July onwards, where I hadn't heard anything back from Rita since requesting the transcript, I requested it to Georgina, I'm pretty sure, and I heard nothing for 10-11 days, so I chased them up on the 26th, and this is the email. Hello Rita and Nana. Now Rita is Rita Lopez, Nana is Nana Matenga. Pardon me. As far as I know, they're the two members of the registrar that were dealing with the matter, and Nana was Rita's supervisor. Hello Rita and Nana. Since the 15th of June 2017, we have been corresponding with mainly Georgina Dawson of Auckland District Court. Prior to the hearing, Georgina stated via email, attached email number 5, date 29th of June, that we can request a transcript of the hearing. Furthermore, during the hearing with Judge Tim Black, he stated we could request through the registrar for the email relating to Tim's direction to the court staff to have my possessions, namely the recording equipment and phone, taken from me prior to being heard. Yet we had given notice of intent to exercise rights and freedoms expressed within the New Zealand Bill of Rights Act 1990, Section 14, and Georgina had failed to state what legislative law would prohibit or infringe upon this right. See attached email 6, my response to Georgina. We were surrounded and intimidated to surrender possessions by forced security, without a reason other than a direction from a judge. We wish to know what rule or law gives Auckland District Court staff the right to do this. This was done under duress and protest. As a party to the proceedings, we believe we had the right to keep an independent record of such, yet this was infringed upon. Again, see email 5, 29th of June. Perhaps it was the behaviour of Tim on the bench that Auckland District Court wished to keep hidden, for which he has now a complaint filed against him with the Judicial Conduct Commissioner. We formally request and require the transcript relating to this matter, as well as a complete copy of the file to date. If there are any costs, please advise. We also wish to know why Georgina has not responded to our correspondence and requests since. Due to Georgina's passive acquiescence, she has, in our opinion, confirmed bias and unwillingness for transparency and accountability. See bottom of email number 17. We attach also our own transcript of the proceedings that day, showing where Tim stated we could make a request for his directional email. Attached transcript CRN 170041768889, page 4, line 6. We appreciate your efforts in fulfilling our formal requests. We look forward to your response. Warm regards, ladies. Again, I didn't seem to be getting any response whatsoever, so on the 4th of August, 9 odd days later, I sent another email. Good morning Rita and Nana. As we have heard nothing from either Nana or Rita, is there a possibility either of you might reply soon? As to avoid phoning or popping in to see either of you in person and wasting our valuable time, as you two are being paid for yours. Notice, failure to respond shall constitute a tacit agreement that Rita Lopez and Nana Matenga are complicit with other staff of Auckland District Court's failure to respond to our formal requests, and shall be construed as failure to provide services which we are entitled to. Is there a problem? Please advise without any further delays. Best wishes. And that was at 9:15 or 9:14 in the morning. Okay. Now, at 9:41, 27 minutes after that, Rita Lopez actually responds, "Hello Mark, attached herewith is an email correspondence that was sent to you." Rita. Okay, sounding interesting so far. And it says documents attached, direction of His Honour Judge Black, dated 13th of July. And 2, transcript of the directions held. And there's also a no-name email which shows Rita requesting direction from the judge to have my stuff taken off. So the judge wouldn't have done that if Rita hadn't asked for that direction. Okay. And so I replied at 7 minutes after that to Rita. "Hi Rita, that was not sent to us until now. We have heard nothing from yourself until this reply. We do believe this was sent to when do you believe this was sent to us? We will review your response and get back to you shortly. Have a great day. Me." Note, due to no response from either yourself or Nana until now, a complaint has been filed with the Ministry of Justice. Okay. 6 minutes after that, Rita replies again. "Mark, the email contains details of the date and time it was sent. The documents you have requested have been given to you. Any further correspondence on this matter should be filed via a memorandum which will be referred to a judge. Thanks, Rita." Thank you, Rita. So I respond to Rita. "Hi, Rita. Although the transcript has some errors according to our video record, thank you. You may believe you sent it to us on the 2nd of August 2017 at 11:23. However, as our email address is, and I'll leave that out, and not my email address missing one letter, you missed the K. This would explain why we did not get it. Did you not receive it bounce? We will allow you this mistake. Please explain what justification the registry has to have my possessions taken. Infringing on rights, Auckland District Court were notified of our wish to exercise. We will be keeping an independent, impartial video and audio record of the proceedings scheduled for the 7th of November. If yourself or Auckland District Court claim to have some authority to infringe on rights expressed within the New Zealand Bill of Rights Act 1996 and 14, please supply without delay. Notice, should the registry, Auckland District Court staff, security, or another dishonourable judge like Tim attempt coercion, threats, intimidation, and infringe against us again, we will hold each man or woman personally liable for their actions. You have been notified. Notice, all shall be published for maximum accountability and transparency. Warm fuzzies, me. I wanted to add a few more questions to Rita some 14-15 minutes afterwards, so I sent Rita another email. Refer to last email in regards to your error and belief. Any further correspondence we wish to have with Auckland District staff, District Court staff, will be done as we wish, however we wish to do so. Of course, asking for the name of the judge would be pointless, yes, as Auckland District Court will not release it, correct? The document requested have finally been received today, 4th of August 2017. We will accept your apology for your error in advance. We would suggest the registry show evidence to support their theft of our possessions on the 13th of July 2017. As Georgina failed to supply any, you may or may not have better luck justifying Auckland District Court's actions. Judge Black can enjoy the complaint filed against him for his vexatious and dishonourable actions. Given the Judicial Conduct Commissioner is supposed to instill public confidence in the judicial system, we will expect the opposite. But that's another matter for Alan Ritchie, isn't it? Again, have a terrific day, Rita. Me. So, after I sent that reply back to Rita, or the second email to Rita at 10:30, I lodged a few questions to the contact us at the Ministry of Justice. They gave it a reference number, which is all dink and dandy, and basically I got an email here from a lady by the name of Jean. Dear Mark, thank you for your email. Your query has been forwarded to Rita Lopez for follow-up and response. So I guess Rita knows now that I've also contacted the Ministry of Justice in regards to not getting any information. So I responded to Jean. Hi Jean. I did chuckle. Thanks. It would appear that Rita had an error, sent the transcript and copy of a directional email to an incorrect email address. I have now received them. I have had no answer from Rita in regards to Georgina's lack of response, nor have I received any reasoning from Rita to infringe on my right to record and have Judge Tim Black direct for Auckland District Court staff to intimidate and confiscate my possessions, especially as I gave formal notice I wish to keep an independent record of it. Now, after creating my own transcript from the recording that Auckland District staff failed to stop from being taken, and comparing what was actually said versus Auckland District Court's version of the transcript, words and sentences have been added and removed to suit, it would appear. I will be releasing the results of my investigation of court transcripts and their accuracy soon, publicly, and that was part 9. This only strengthens why court staff would attempt to covet and control the public proceedings by denying such recordings. So I ask yourself, Jean, what authority and reasoning would Rita have to do this? What cause did she have? I was told by security on the day that it was due to postings on YouTube. Without a shred of evidence or specifics, how does freedom of expression justify my possessions being taken and rights being infringed upon? Denying my entitlement to keep a full and impartial record of the matter, or be denied my right to be heard and be forcibly removed because I had a camera or 4 on? Here is the link to Judge Tim's unimpartial actions and behaviour, and I send them a link of part 6. The $80 ticket series shows every piece of correspondence from the beginning up until the 15th of July. There is a lot more yet to follow. Please, Jean, try to explain the reasoning for the infringement or abrogation of my pre-notified and expressed wish to record, backed with legislation, New Zealand Bill of Rights Act 1990, Section 14, as Auckland District Court staff appear to have acted improperly, without justification and outside their scope of authority. P.S. I have had no reason to date supplied by Rita for her to seek direction from Tim to have my equipment taken under duress and protest, let alone on camera. Should I ask Nana Matenga? I already did. And I get a response back from Ronita on the 9th of August. Now that one was sent to Jean on the 8th of August in response to her telling us, thanks, we got your complaint through and that was on the complaint website of Ministry of Justice. That's why I don't have a copy of it here. 9th of August. Dear Mark, Thank you for your email. Your queries have been forwarded to Rita Lopez for a follow-up. Ministry of Justice staff can provide general information about the courts, including court forms and processes, but cannot provide legal advice. If you are inquiring about which legislation supports your particular case, we recommend you contact a lawyer for advice. A lawyer can help you understand your legal rights and responsibilities. What about my natural rights, my inherent rights? Whatever the fuck I wish to do. What about those things? Or is it just legal rights? And explain how the law applies to your case. If you do not have a lawyer, you can get free legal information from a community law centre. Why would you want to contact someone who's batting for the other side? Every lawyer that's registered with the Bar Association has their first duty, first and foremost, to the court. To their client comes secondary. So they are always playing for the other side. They are there to translate the legalese into common English, or general English for people to comprehend it. That's why they always say, oh, I'm not legally trained, because they don't speak the language. Moving on. Community Law Centre, or alternatively the Citizens Advice Bureau. For more information on their services and locations, please follow these websites. Yeah. Been there many a time. They love me. Renita, Customer Services Representative. So on the 11th of August, after not hearing anything from Rita for a week, morning Rita, please explain your cause and justification to seek direction from Judge Tim Black to have my positions taken without delay. Failure to respond shall constitute a tacit agreement that Rita Lopez of Auckland District Court has acted outside her scope of authority and is liable for prosecution. Regards, me. And then I sent a further response to contact us. Hi, and this is in response to their email of the 9th of August saying that they can inform me on court processes and that sort of jazz. Hi, thank you for your response. As you have stated you can advise us of court processes, please answer the following. 1. As a party to the proceedings, do we have the right to keep an independent and impartial record of said proceedings? 2. What rule or process allows Rita to seek direction from Tim to have my property taken without cause or justification? 3. What is the process or procedure around keeping a digital record of the court process? 4. Is the New Zealand Bill of Rights Act 1990 applicable at Auckland District Court? 5. As we are presumed innocent, how can Tim presume jurisdiction without evidence? 6. Is it prosecutorial misconduct for the prosecutor not to satisfy subject matter jurisdiction prior to a plea being entered? 7. How is subject matter jurisdiction established? 8. Do we have the right to enter a fully informed and voluntary plea? 9. Does the court accept an uninformed plea? 10. Why were we threatened, demeaned and yelled at by Judge Tim Black? 11. How corrupt is the judicial system? 12. Can a judge practice law from the bench? 13. What does the judge represent? Please answer these simple questions or points of clarification without delay. Rita seems to be mute and non-responsive, so passing these questions on, passing the buck, will not suffice, although her passive acquiescence speaks volumes. Should no answers be given, we will attend Auckland District Court of another district court with our cameras rolling to seek clarification face to face. Should any public servant choose to obstruct our rights being exercised, they will be held personally responsible. Note, we do not understand your confidentiality disclaimer and may or may not do as we wish regardless of your belief. On the 11th of August, I also sent to Nana Matinga. Hi Nana, please explain why Rita Lopez has failed or refused to answer or justify her reasoning for having my possessions taken under protest and duress. Warm regards, me. And I get a response back from District Court correspondence saying, please see attached correspondence of your emails the 11th of August. So in other words, they're sending me an answer to my questions, and I sent them on the 11th. Okay, so here is what I got from the Ministry of Justice, dated the 29th of August. Dear Mr. Keane, District Court at Auckland, I acknowledge your email of the 11th of August in which you have asked questions about your case at the District Court at Auckland. Your email has been referred to me for response as the matters you raise fall within my responsibility as Group Manager, Courts and Tribunals Regional Service Delivery. I understand that you are concerned with the way your case involved was progressed by the registry and considered by the judge. I must advise that as a government official, I cannot intervene in or comment on judicial decisions made by either judges or registrars. No judicial decision there. Hadn't even been heard for her to say take his shit off him. Courts and tribunals are judicial bodies that must operate independently from the government. Ministers and officials to ensure the judicial process remain free from any outside interference. However, I am able to make the following general comments which I hope are of some assistance. Oh my God. Might as well put it down now. Court proceedings are recorded by the registry, and access to the recording is governed by the legislation. Okay? What legislation? If you require a copy of this recording, you will need to contact, in writing, the court at which your case was heard. You will need to identify the particular records you wish access and give reasons for your application. Done that. Done that. Your request will be considered by either the registrar or, if necessary, a judge, and decisions relating to the release of court recording is a judicial decision and may attract a fee. The Ministry of Justice cannot intervene or comment on the decision-making process. So she's telling me shit without backing me with any specific legislation and telling me it may cost me if I want their recordings. Why on earth wouldn't I want to do it myself then and not attract a fee? Or again, does the Bill of Rights, the freedom to seek, receive and impart information, not apply in that courtroom? Further to this, if you want to film or record proceedings in court for publication or broadcast, well, what about just to keep a record? Who said anything about for publication and broadcast? I did give notice that it may be published on maximum accountability, but that's my right to do so. So, or wish to photograph a court in session, you must apply in writing through the registrar of the court concerned. I don't need to apply for something that is a right I'm exercising. Applications are approved or refused at the discretion of a judge. I understand that Judge Black has directed that you are not allowed to film in court. No, he hasn't. No such direction's been given. He directed to have my shit taken off of me. No, nothing. Me recording was not even discussed. It was already decided upon before I even got to have a mention whatsoever. As outlined above, I am unable to comment on judicial decisions, so she can't comment on the fact that Judge went ahead and did that. Or, so my question is, I can understand that he probably made a decision because he was asked to by the registrar, i.e. Rita Lopez. I want to know what reason did she have to seek that direction. You getting it? To have my shit taken off me, not stop me from recording. That was never discussed. It's the fact that they just thought they'd take my shit off me. I am unable to comment on your concerns regarding the conduct of a judge. Oh, she's good at telling me everything she's unable to do, isn't she? Your complaint should be sent in writing to the Judicial Conduct Commissioner in the first instance. Did that on the 14th of July, the day after the prick tried it on me. More information can be found at jcc.gov.nz or by contacting the Judicial Conduct Commissioner, PO Box blah blah blah, phone 0800 800 323 or 04472 6158. You cannot use this process to complain about a judge's decision or a decision a judge has made. He hadn't made any decision. He was just trying to get me to enter a plea. I was just trying to find out the cause and nature of the proceedings. If you believe the judge's decision is incorrect in law, you should seek advice from a lawyer on how to proceed. Back to just ask somebody who's working for us on the sidelines sort of comment. In other words, pass the ball sideways. If you do not have a lawyer, you can get free legal information and advice from your nearest community law centre. More information and services and location of community law centre is available at the following and another referral to communitylaw.org.nz. I trust I have clarified these matters for you. No. Yours sincerely, Jacqueline Shannon. Thank you, Jackie. So, that was the 29th. On the 1st of September, after I had a couple of days to ponder on it, I sent this to Jacqueline Shannon. Greetings, Jacqueline. We thank you for your correspondence dated the 29th of August 2017, which we received on the 31st of August 2017. It would appear there is some misunderstandings according to your correspondence, and this has left us with more questions as you have failed to clarify anything thus far. Firstly, our questions and points of clarification are as follows. 1. What justification or reason did Rita Lopez have to request direction from Judge Black to have my possessions confiscated? 2. Security, Grant, stated it was because of stuff posted on the internet. Is this correct? 3. Do we have the freedom to seek an independent record of any proceedings? 4. In any form we wish. 5. Is the New Zealand Bill of Rights Act 1990 applicable at Auckland District Courthouse? 6. Is the New Zealand are you aware that we had given notice of our intent to exercise our freedoms expressed within the New Zealand Bill of Rights Act 1990 Section 14 over a month before attending? 7. Are you aware that Georgina Dawson, Rita Lopez and Nana Matenga have all failed to provide any answers to my simple questions to date? 8. Is it not prosecutorial misconduct for the prosecution to fail to supply evidence of subject matter jurisdiction prior to a plea being entered? 9. Do we have the right to make a fully informed and voluntary plea? 10. Does the court accept an uninformed plea? 11. Where do you derive your belief that we require permission to exercise an existing freedom or right? 12. Judge Black at no time directed us not to record. Where have you derived this belief from? 13. Judge Black gave direction to have my recording equipment relinquished after Rita had asked for it. Why did she instigate my rights being infringed upon? 14. Even though their best efforts to stop our recording and intimidate us failed, luckily all interactions with everyone was recorded. Are you aware of this? 15. Can a judge practice law from the bench? 16. Is not every lawyer's first duty to the court and the client secondary? 17. We have not required you to intervene with the court process or the judiciary. Where did you derive this belief? 18. We did not want at any time to record this matter. Instead, it was our wish to exercise our pre-existing freedoms to do so, without any violation, obstruction or infringement against us. Can you comprehend the difference? Yes? 19. We already have a copy of the transcript, although factually inaccurate, from Auckland District Court. After Rita had sent it to the incorrect email address, she corrected her error. Are you aware of this? 20. Every single bit of correspondence, including Judge Black's disgusting behaviour, is published for maximum accountability and transparency. Are you aware of this? 21. We made a judicial conduct complaint against Tim Black on the 14th of July 2017, which is still ongoing. Were you not informed of this? 23. Do you have the ability to ask Rita why we were trespassed against by her actions that day? 24. Do you have any authority over court staff, not fictional titles, entities such as the registry or the court, which they hide behind, but the actual men and women acting in those positions and capacities. Please answer all questions point for point. If you lack the ability to do so, write no comment on any question you have confusion over. We would be happy to clarify any question for you if necessary. Here are all the parts published relating to this matter to date. More will follow. And I sent her all 1, 2, 3, 4, 5, 6, 7, 8 parts. That was prior to doing the transcript. Part 9. Part 9 will be published soon. It shows the inaccuracies between the video, audio and the transcript supplied, which only enforces the need to keep an accurate and independent record of any matter, in our humble opinion. Notice, we do not require permission to exercise rights affirmed and expressed. Therefore, we will continue to express these rights whenever we wish, without asking for any permission, unless evidence to the contrary can be provided. Notice, all correspondence shall be published on multiple forums for maximum accountability and transparency according to rights and freedoms expressed within the New Zealand Bill of Rights Act 1990, Section 14. Notice, failure by Jacqueline Shannon to respond within 10 days shall constitute a tacit agreement that Auckland District Court shall not infringe against our rights and freedom to seek, receive and impart information and opinions of any kind in any form. We look forward to your reply, and remember that silence is passive acquiescence. Warm regards. Have a wonderful day. Me. And that same very day, I get an acknowledgement letter. Dear Mr. Keane, I acknowledge receipt of the correspondence below. The standard time frame for a complaint of this nature is 20 working days. However, we will endeavour to correspond to you as soon as possible. Regards. And this is just signed by official correspondence. Man, you got some weird named people working at Ministry of Justice. I mean, there's Jean, there's Rita, there's Nana, there's Juanita. Now you've even got people called official correspondents. Fuck, they did not like their kids much, those mother and father, did they? Anyway, so even though I told them they've got 10, they were asking for 20. I didn't bother responding to that because I figured, whatever, I'm not going to argue the difference. As far as the police prosecution service is concerned, I sent a very similar set of questions to them as well. I will endeavour to get that up and posted for everyone to see. I have not heard a beam from those fuckwits since since they were at the court hearing. A. Hicks was there for the prosecution. Don't know who A. Hicks is, but yeah, I sent a correspondence to her and have got no response at all. I've asked for the full disclosure under Section 13B or Section 13A of the Criminal Disclosure Act. Got nothing. I'm expecting to see a witness list or a deployment registrar of the vehicle, of the camera, or a competency certificate for the operator, or some sort of details to show that it was actually a temporary speed zone that day, and perhaps something even showing me doing 80 kilometres an hour. A photograph, well, yeah, but my vehicle appears stationary in that photo. It doesn't appear that I'm doing 80k. If you want to know what 80k looks like, look at Constable Neil Winterbottom in my local neighbourhood when he goes chasing little old ladies doing 60k an hour, doing 80 flying past me with one arm out the window giving a wave. If you want to see what 80k's, put evidence of what that actually looks like, you watch that, because that's what 80k's looks like going screaming past you. It doesn't look like a photograph. So, yeah, ball's still in their court, still waiting for them. Judicial Conduct Commissioner are going to get another chase-up email from me shortly, because I'm really fed up with hearing absolutely nothing from them. And yeah, notice I didn't get in a complete case file from Auckland District Court that I required, even if it did cost a fee. Nothing about that was mentioned. And yeah, police prosecutions, I suggest you get your shit together, because as it stands, you failed to respond. and by failing to respond it is construed that your claim or your alleged charge that you have no evidence or basis or foundation to back that by not responding. In case you didn't notice the little failure notice at the bottom. But like I say, that'll be in the next videos I post up very shortly for all to see. Yeah, perhaps even a little chase up email I send them. So we'll see how we go. Catch up with you later. Bye. Sorry for the long video, but it's been a while. See ya.